Good evening, everybody, and welcome to Fox Williams. For those of you who don't know me, my name's Steve Sidkin. I'm partner at Fox Williams, and it is my privilege to lead our agent law team. This evening, as perhaps a slight variant from previous agent law seminars, we actually have for us a guest speaker. My partner, David Williams, who is an employment law specialist. He and my partner, Evie Meleagros, are going to be talking about the subject of secret commission or unauthorized payments. I will share with you, we are certainly coming across increasingly payments being made, and one wonders as to the legality of the actual payment. No less a situation some years ago now when a client that I was meeting with, one of my colleagues, said to me, "I'm going to tell you something. Not even my wife knows." At which point my mind started spinning. The client continued, "I've got a secret bank account. And I'm thinking the Caymans, I'm thinking various offshore centres, I'm hoping for a site visit." And it turns out that he did have a bank account, and it was secret so far as his wife was concerned, but it was in either Eastbourne or Bognor Regis, so not necessarily a site visit. And he was using it to receive monies that he shouldn't have been receiving. Yeah, it does happen. So moving on from that, we have seen over the course, certainly of the last 12 months, and I'm sure we will see it going forwards, a variety of different businesses be the subject of cyber attacks. And we have read the consequences of when that has occurred. And indeed, some of you may have either been the subject of such attacks or know of others who have been, or worried about whether you were going to be the subject of such attacks. My colleague Guy Haslewood is going to be talking about not specifically the issue of cyber attacks, but in terms of the terms upon which you carry on business. All too often we come across situations, particularly with the concept of force majeure, where what we're seeing is perhaps not what the client hoped we would be seeing. I won't say any more because otherwise I shall be stealing Guy's thunder. We were due to have another of our colleagues, Jessica Howard, here this evening. Unfortunately, Jessica has not been well. And as a result, our colleague Ashkon Camyab has stepped into the breach. So thanks, Ash. He's going to be talking about what may be regarded as a somewhat dry legal issue, that of the issue of the agent being authorised and who or what is authorised. Again, we have seen over the course of the last 12 months, indeed, Ash probably doesn't know this, but there was a judgment handed down last Friday on this very issue, which I haven't shared with you because I didn't want to spook you, in terms of who or what is authorised, and more particularly what it can mean when you're entering into a contract, what it can mean when you're hoping to find your way out of a contract without having to talk to probably Evie as a litigator. And lastly, I'll be addressing the issue of indemnity, which is one of the two main post-termination payments to which an agent may be entitled. And I'll hopefully be talking you through a variety of different issues so far as that is concerned, but more particularly dispelling some urban myths. I'm going to be speaking from the lectern at the end because I'm the last formal speaker. And before that, Guy and Ash will also be speaking here. But Evie and David, as a double act, are going to be talking from the table. So without further ado, let me hand over to Evie and David. And there you are, secret commissions. And by the way, Evie does tell me she does have some free samples.
Good evening, everyone. Thank you for coming. I thought sitting at the table would be a good idea when there's two of us to say I was getting up and down, but now I'd rather not do this. But right, secret commissions. The obvious first question is, well, what is it? Well, I was going to start with what is it, but Steve's ruined that by saying at the beginning what it was. I was going to ask one of you in the audience, but I won't do that now that he's giving me the answer. It sounds really obvious. Secret commissions, an undisclosed payment or an unauthorized payment, as Steve put it, which is obviously a bad thing. So what is she going to talk about and how long we're going to have to sit here and listen to this? But, it can be less obvious than you think. So it is an unauthorized or undisclosed payment or benefit given to an agent by a third party without the principal's knowledge or consent. And usually it's done to influence how that agent acts on behalf of their principal. Now, the sort of issues that this brings about in the context of an agency and is similar in the employment context is, why does that matter? In particular, why does it matter if an agent is taking cut if it's not actually causing any harm to the principal? The principal wasn't suffering any loss. It's just a little bit on the side for the agent. Well, agents owe duties to their principal's interests, and I'm sure you all know, above their own personal interests. And taking an undisclosed payment is a breach of fiduciary duty. It's a breach of contract, and it can also be a criminal offence if it is treated as a bribe. So as we've got up here, the statutory duties under the Commercial Agents regs from 1993, you probably already know this, but Regulation 3 sets out a series of duties. I've only picked out the first one. There are other ones that follow that to following instructions and so on. But the one that is of significance in this context is 3 little 1. And I have put in bold the key words there. So performing activities, it still says his, which is by and by. A commercial agent must look after the interests of his principal and act dutifully and in good faith. Well, what do those words mean? Well, interest of its principal is obvious. Dutifully, it usually means loyal, avoiding conflicts. I would ordinarily interpret the word dutiful. And good faith obviously means act fairly. And open dealings. And as you probably already know, the commercial agents regs say you can't derogate from an agent's duties. In other words, you can't contract out of it. And the consequences of a breach of duty, depending on how serious it is, gives the principal a right to terminate. And obviously, I would suspect a secret commission is pretty serious. And in any breach, a principal will be entitled to any losses that flow from that. And there might be a claim for an account of profits in relation to the secret payments that have been received. So how has this played out in case law? So I've got a series of cases there go all the way back to the 1900s. And the law pretty much hasn't changed since then. So in the first case in Hovenden and Milhoff were cigar suppliers. Now, the agent for the claimant bought large quantities of cigars from this tobacco supplier, Milhoff, and Milhoff paid them a cut of 2.5% every Christmas and midsummer for the large purchases that they made. The Hovenden didn't know about this. When they found out about it, they sued Milhoff for the amount of the secret commissions. Milhoff said, why does it matter? The commissioners didn't influence the orders or the conduct of the agent in any way. It was quite common to do that in the industry, and there's nothing unusual about this. The fact that the claimants didn't know didn't matter because it didn't cause them, there was no loss to them. The court disagreed. The court said that any payment without the knowledge and consent of the principal, with a view to induce an agent to act in favour of the donor, is a bribe or secret commission. And it was the undisclosed sort of lack of consent element that made it improper, and that then made it a breach of duty. And then all those overpayments that were made, the vendor could claim back. Skip forward 100 years or so to Image View Management and Mr. Jack, which in case you may know about. Mr. Jack was a footballer. I don't know if he still is a footballer. He wanted to sign, I can't remember what country he was from, but he's from the outside the UK. He wanted to sign with a UK club. He entered into a 2-year contract with an agency where the agent would receive 10% of his earnings if if and when he got into the UK club. He signed with Dundee United. I'm guessing he was in the Dundee club. I'm guessing it's Dundee United. And separately from the agent arrangement with Mr. Jack, the agent made an arrangement with the club, the football club, to receive a fee of £3,000 in order to get Mr. Jack a work permit. Mr. Jack didn't know about this. He didn't know about this separate arrangement. When he found out about it, he sued them for it, and it amounted to a breach of their duty that the agent owed him as principal, because it was again an undisclosed payment. It wasn't acting in his best interest. It was in their own interest. They put their own interest before his, and it didn't matter that it ran parallel to the agency and that it was a separate agreement. It was still a breach of fiduciary duty, and it resulted in a forfeiture of the commission, £3,000 that they received. And Mr. Jack was also entitled to a repayment of the fees that he paid that agent to date and didn't have to pay him anymore. And then in the next case, FHR European Ventures, this was in 2013. This was a case involving the purchase of a hotel, and the agent in this case arranged the purchase, and it was worth a few tens of millions. This case went all the way to the Supreme Court, and it concluded that where there is a bribe or a secret commission received, the agent holds that payment on trust for the principal, and the principal then has a proprietary claim to it. What that means is that payment is the principal's. It is the property of the principal's. It never belonged to the agent. So it's not a debt or anything like that. It is an asset that the principal owns. So the principal is always entitled to recover it. And finally, as recently as 2025, this summer, is the last case, Charles Clare, Links Golf against Mr. Wugar. This actually isn't an agency case, it's a consultancy arrangement. But the court analysed the contract and took a view that even though there isn't an agent, they concluded there was no agency relationship because Kevin did not have the right or power to sign off on agreements or not, but and enter into arrangements on behalf of the principal. But they determined that the consultancy agreement imposed enough of an obligation of trust and confidence in the consultant that the contract imposed similar duties upon him. Now, it was held to be a secret commission, but I think it's just a straight fraud. He negotiated with a supplier of golf heads for Charles Clare, the principal, and he agreed a base price for these golf heads, and that was all fine, and Charles Clare agreed to all of that. He then created an invoice via a different company, so a third-party company, I don't know what it's called now, Astor East or something like that. He used this company to create an invoice for these golf heads. He increased the price, so he took the base price and added on something to it, and sent that pro forma invoice to Charles Clare and says, here's the invoice for these golf heads that you have to pay. Charles Clare thought that was the cost of that was the factory costs and so on for these golf heads. They paid this invoice to this third-party company. Lo and behold, Kevin is connected to this company. He takes the payment, goes into the third-party company. Kevin pays the previously agreed price for the golf heads to the manufacturer, and he keeps the rest for himself. And there, Charles Clare eventually find out about this and sue him, and he has to pay it. And that is an extreme example. That is not just a secret commission. That is also falsifying invoices, and raises all sorts of problems for poor old Kevin. But that was what the court says. Even though he wasn't an agent, he was trusted to carry out a role honestly, and he did not. David?
Great stuff. So on to the employment aspects. So I'm going to start off by sort of giving you an example of secret commission. So we were acting for a company. There was a suspicion. I think it was triggered by an individual had a car and they thought it was a bit flashy, and they weren't quite sure where the money came from. I think it was actually a Ford Fiesta. It was actually a nice model, which I'm not sure would necessarily spook suspicion. And someone phones up and said, what should we do? I said, well, why don't you have a look into it? Just make sure that all the money received is going in the right place and everything is tickety-boo. So they've got his manager to do it. The manager does a bit of an investigation. It didn't feel particularly diligent, but it came to nothing. So the manager, the boss, said, actually, this doesn't look right. No, I'm not sure that we've looked into everything. I'm going to get his manager to look into it. He looks into it. Again, not much of an investigation. Doesn't really dig very deeply. There's nothing there. Everything comes to a head when a third party tips off and says, we might be paying you some commission. They didn't quite know that was happening. It's all related to no bonus arrangements. We looked into it again, and what was happening is the individual we investigated originally was going secret commission. Well, he got a cut of it because he was sharing it with his manager, and he was sharing it with his manager's manager, who had investigated. And it just goes to show how sometimes these things unravel. It was being disguised by discount arrangements, and a bit of a gut reaction led to that investigation. So from an employment aspect, and as Evie's mentioned, there are basically two duties. There's a duty that applies to all employees, and again, these sort of things may not involve employees, but to the extent they do, you've got the duty of fidelity. So it's a duty to act in good faith, or as Evie mentioned, to basically act fairly. If you're receiving a secret commission or a commission, it should be directed towards your employer. It's pretty simple. And if there's a breach of that, then you could sue your employer for damages. That tends not to happen. They tend not to have that much money, but you sometimes do it. It may have an impact on a bonus, that's drafted in a sophisticated way. You may be able to claw some of that back. But the most likely outcome is that you might think about terminating the individual's employment. And if they have more than 2 years service, that's affected by the unfair dismissal regime. So it's really important that you investigate properly and independently. So maybe getting the manager wasn't quite a good decision, looking at all the facts. And then you hand over to someone independent who can deal with the disciplinary proceedings and then terminate. If you don't do that, then there is potential for an unfair dismissal claim. The compensation is up to a year's pay, capped at about £120,000. So, again, really important to follow that and follow your processes. We've got the duty of fidelity, but there's, of course, this higher duty. If someone is in a trusted role, a direct or senior role, it's possible they're in a fiduciary relationship, and then they need to act in the utmost best interests of the employer. That's a much higher standard. As Evie mentioned, that can be applied in relation to certain fiduciary arrangements. If there's a breach of the fiduciary arrangements, then there are sort of special consequences. The fiduciary must compensate for loss. Any potential arrangements could be rescinded. The fiduciary must account for profit, which is an interesting one that doesn't apply to a fidelity arrangement. So all of that needs to be taken into account. But when you're looking at all these things, and if you do have employees who are involved, it's important also to look at the employment contract. Sometimes the employment contract will try and promote the duty of fidelity to a duty, a fiduciary duty, by saying, okay, you're an employee, you're not a fiduciary, but we do expect you to act in a certain way and disclose information and to act in our best interests. So it's always worth reviewing that. And again, if having policies, and we'll come on to some preventative steps, but there may be policies which are essentially guidelines, directions that we'll go into staff. It's skills that they're trained properly, understand these policies, and if they actually reach, then again, you may want to take disciplinary action.
Bribery. So, we spoke about secret commissions, quite similar to a bribe. And I think we spoke about the Bribery Act in the past, but the Bribery Act in 2010 makes it a criminal offence. So you might well have been taking, the agent might be taking the secret commission, undisclosed payment, but it might also be classified as a bribe, and then we're into criminal offence territory. And so the Bribery Act makes it an offence to pay or receive a bribe directly and indirectly. A bribe is what we all know what a bribe to be as. It is an offence to bribe another person, offering, promising, giving an advantage to a person to induce them to perform in a certain way. And it's an offence to be bribed, so accept, receive, requesting an advantage to a person with induced performance. And it's obviously an offence to bribe a foreign public official. We probably don't need to worry about that from this purpose of this talk. It is extraterritorial. That means it doesn't matter that it didn't happen here. It doesn't have to be connected to the UK or be brought in the UK for the Bribery Act to bite. Section 7 of the Bribery Act also imposes a further offence, which is on organisation for failing to stop a bribe happening. So you've got the underlying actual bribe, and then there's a further offence that if it happened in your organisation, you didn't do anything about it. And we'll talk a little bit more about that in the next slide. But effectively, that is a strict liability offence. So if the underlying bribe is established, that if you prove the bribe has taken place and an organisation doesn't have proper procedures in place, like a bribery policy, something like that, then you can be found liable for failure to prevent the bribe, whether or not you knew about it. That's the senior management level. There is a reference to an associated person in the Act in terms of who the bribe is offered to, or who is accepting the bribe, and an associated person includes employees, agents, and subsidiaries of the organisations. The only defence to the Section 7 offence in the failure to prevent is proving that you have adequate procedures in place to prevent bribery by persons in the organisation. Following on from the Bribery Act, they've gone one step further. This is the Economic Crime and Corporate Transparency Act that came out in 2023. But what I'm going to mention in particular for the purposes today is a new criminal offence which kicked in on the 1st of September, which is the failure to prevent fraud. So what happened is they took the Bribery Act in 2010, Section 7 of the Bribery Act, saying, right, we're going to impose this additional strict liability for not only is there a bribe, there's also now a failure to prevent that bribe. They've now gone one step further to impose more obligations on organisations, saying there's now a failure to prevent fraud. So it takes a little bit wider. The failure to prevent fraud is a strict liability offence again, so it doesn't matter whether you knew about it or not at director and management level. And it applies to large organisations where a person who is associated with the organisation commits a fraud offence intending to benefit the organisation or any person the associate provides services for. And that word needs to capture people like agents. Now, this is about benefiting the organisation, not where the organisation can be a victim of the fraud. So what is a large organisation? There are 3 conditions under the Act that and 2 of them need to be satisfied as a minimum in the financial year prior to the year of the fraud takes place. Now, a large organisation is quite large. It's a turnover of more than 36 million, a balance sheet total of more than 18 million and more than 250 employees. So you only need to satisfy 2 of those requirements. So a lot of organisations, when this came out in September, over summer when we were talking to clients about it, a lot of clients said, well, I'm smaller than that, so I don't need to worry about this. But it doesn't just capture large organisations only. If you're a subsidiary of an organisation that meets that criteria, you're also caught by the Act. And an associated person is again similar to the Bribery Act. Anyone who's an employee, agent, subsidiary undertaking of the organisation is captured by it. Interestingly, it doesn't apply in respect to the supply of goods at the moment, so it's only related to the supply of services. And the offences, so you've got the failure to prevent fraud, the underlying fraud offences that it bikes upon are listed in Schedule 13 of the Act, but they're essentially all the stuff you'd expect it to capture. So anything under the Fraud Act, anything under the Theft Act, criminal offences under the Companies Act, fraudulent trading, stuff like that is all captured. The underlying fraud obviously has to be proved, but as soon as that fraud is proven, then the strict liability on the failure to prevent kicks in, unless you can rely on the limited defences that the Act provides for. And again, it's very similar to the Bribery Act. It's all about policies and procedures that you've got in place. And the Act talks about prevention procedures and defines that, but it's what you would expect it to be. It's fraud policies and so on. But there's the other defences the organisation was not reasonably expected to have any prevention procedures in place. So what is a prevention procedure and what is appropriate will always depend, and what's reasonable will always depend on the organisation, not just its size, but also the level of risk it's exposed to in a fraud context. The Home Office has published guidance on this, which is as useful as you can imagine it would be on the government website. But what an organisation will need will vary hugely. It might be that you need a suite of policies that deal with all these things. It might just be that you need regular training. It might be that one-off training is enough. It might be some, warm and fuzzy wording from senior management saying we don't tolerate fraud. But it's just worth being aware that this is out there. It's very new. So there's been, at the moment, it's just all we've got is the virus on the Home Office website. But it is, bribery act with bells on.
Bribery bells on. So, okay, so now onto some other considerations, just to wrap this section up. A few other considerations. The first one is tax. So if you receive secret commission and you don't declare it to the revenue, then that's essentially tax evasion, and that might be the least of your problems. It's always good to go down for tax. Competition, again, it depends how widespread the secret commission is, but if it's been offered to someone and all the competitors, it may distort the market, will lead to some sort of unfair practice. Whistleblowing comes into play because someone might notice this and blow the whistle. It's really important that you deal with these people in an appropriate manner. You don't treat them detrimentally. Lots of employers trip up, particularly if it's an annoying employee who has raised the issue. But if people do raise issues, take them seriously, deal with them properly, and investigate and such like. There's a potential for discrimination. We've seen employers in the past let some people get away with certain things and not others, and that's led to claims. And when you deal with these claims and it's all about slightly dodgy territory in an employment tribunal, it does not make anyone look more good. And that kind of leads us into sort of reputation issues. If these things come to light, they might lead to employment tribunal, they might lead to a prosecution. It's one of those cases where everyone looks bad because someone might have done something that, to the extent it happens in relation to your business or your business area, that's also going to tarnish you. So it's really important that you try and avoid it, which is a really nice segue into practical steps to avoid the issues. And some of this, I've actually read the government guidance. I completely agree. It's difficult to interpret, but you can distill it into basic steps, which is monitor what's happening. You're aware that, bribery and the secret commissions can happen. What steps can you put in place to try and stop that? What sort of signals should you look for in your business in relation to your arrangements? You need to create clear policies. They don't have to be overly sophisticated, but just make sure everyone knows this is wrong. I deal with so many employment cases where the junior employer goes, yeah, I've been doing that, and my boss said it was all right, and they don't really apply their mind. I haven't thought it through. It's not really a defence, but it does often happen. Create these policies. Make sure people are aware of these policies. It could be your staff, but also the parties that you interact with in a business sense. And on the back of having policies, it's really important just to train people. It can be low level, but just so you go through it, you point out examples, you make the policies come alive rather than just have something that's really dried that everyone gets really bored with. It's really important, if you can, put steps in place so any issues can be reported. It could be a helpline or a trusted person within your organisation that people can reach out to. And one of the really important aspects of a preventative duty is one of those kind of links. Review what's happening. Has anything gone wrong? Is there anything you can do better? Has the business grown? Are you reflecting on different types of business arrangements? So review it from time to time and think about whether you can do anything better. And also the next thing is have an action plan. Just think about what you would do if things start to go wrong. I mean, the important thing is, do a bit of investigation. Do you need to suspend people? And if so, how are you going to do that? Will that be a third party or would it be a member of staff? As I mentioned earlier, make sure it's investigated properly. Someone who's distant from what's happening, maybe someone independent coming into your business, although lots of employers don't like that. If you're going down a disciplinary route, make sure you've appointed someone who's senior and independent so that any disciplinary process sticks and you don't end up paying compensation to someone who is essentially a tower. If a criminal matter occurs, one thing you need to think about, and see might have to shut your eyes to this, is whether you contact the police first or you deal with it internally. As an employment lawyer, I like to deal with things internally, because otherwise the police start investigating and people say, I'm participating in internal processes because I've talked to the police and I don't want to prejudice myself. And it can become very complicated and very annoying. And it may mean you have to suspend some potential full pay whilst the police deal with their issues. And that's really painful. So from my perspective, and again, you might want to just deal with it internally, get to a point where you can make a decision and then report it to the police as appropriate. You need to, take legal advice on the best approach to recovering sums. And you might also want to think about the commercial arrangements with third parties. Okay, this has happened, but do we declare it? What should we do? And what's the right thing? Again, with a view to protecting the reputation of your business.
Good evening, everyone. My name's Guy Haslewood. I'm an associate in the Commerce and Technology team, and today I'm going to be speaking about the questions that need to be answered for suppliers and distributors following the spate of cyber attacks that have occurred in the last 12 months. Everyone in this room, I suspect, will be able to name a business that's recently been a victim of a cyber attack. No prizes for anyone who says JLR, Co-op or M&S. But the examples you can see on the slide are perhaps the highest profile victims, household names, which, as the headlines suggest, have suffered significant financial losses in the past 12 months. The most significant of all losses have been felt by JLR, where the total cost of the cyber attack to the UK economy is now estimated to be 1.9 billion following the 5-week halt in car production, which caused disruption across the length of the supply chain, with up to 5,000 businesses, many of them small or medium-sized ones, in the West Midlands affected. Because JLR is estimated to contribute around 0.6% of total UK GDP, the shutdown has even had macroeconomic consequences, with the ONS citing the incident as a contributing factor to a 0.1% contraction in UK GDP in September. M&S, meanwhile, has recently reported a £324 million hit to profits, explicitly attributing the loss to trading disruption caused by the cyber attack. That incident was so severe that it halted online clothing and home orders for 6 weeks. And although M&S has recovered around £1 million through cyber insurance, this only partially offsets the damage. As with JLR, the impact will have been acutely felt by suppliers, many of whom are unlikely to have been shielded by insurance cover. The attacks on JLR and M&S are not isolated incidents, however. And the chart you can see on this slide shows a wide list of victims, all of them in the retail sector and all in the last 6 months. I won't go through them one by one, but I'm sure everyone recognises those brands. And it's getting to the stage really where we're almost at one a month that hits the press, and these are only the ones that are being reported. The lesson, therefore, is clear. It's to be prepared. But what does being prepared look like for a supplier or distributor from a contractual perspective? The first way in which a supplier or distributor can strengthen its resilience to a cyber attack is by defining malicious cyber attacks as an event of force majeure. I'm sure many of you in this audience will have seen force majeure clauses in a wide range of contracts. The basic idea is to relieve a party from performance and associated liability when performance becomes impossible due to an event beyond that party's control. For this reason, force majeure clauses often refer to acts of God, terrorist attacks, and increasingly in recent years, pandemics as force majeure events. That's to say, events whose occurrence may excuse a party of performance. Unsurprisingly, the question of whether the COVID-19 pandemic constituted an event of force majeure has been heavily litigated in recent years. I remember actually attending an arbitration a couple of years ago with Tom, actually, where the barristers essentially spent the whole day pontificating about whether COVID-19 was a natural peril. And that was in the context of the force majeure clause itself. The concept of force majeure actually originates in French civil law, where the Code Civil historically relieved parties from liability when performance became impossible due to an event that was unforeseeable. This civil law doctrine was later adopted into international commercial practice and contract drafting. When force majeure clauses started appearing in common law contracts, jurisdictions such as England incorporated them not through a native force majeure doctrine, but through express contractual drafting. As a result, modern force majeure clauses in contracts governed by English law are fundamentally civil law in origin, but common law in operation. And what this really means is their effect depends almost entirely on the wording chosen by the parties. So what does a well-drafted force majeure clause look like? Well, a well-drafted force majeure clause should include, at a minimum, firstly, defining what is meant by a force majeure event. Secondly, setting out what happens in case of sustained non-performance. And thirdly, requiring the affected party to take steps to mitigate the impact, including, for example, notifying the other party. The results should provide the contracting parties with a clear framework for responding to operational disruption and reduce the risk of litigation. The slide you can see on the screen now contains what may be termed a basic force majeure clause and definition of force majeure event. When we review contracts, we often see examples of generic clauses like this, or worse still, businesses simply copying and pasting from another business's contract, which is an ill-advised approach for three main reasons. Firstly, it actually constitutes copyright infringement and is therefore illegal. Secondly, it fails to take account of which provisions are actually relevant to the contracting businesses. And thirdly, it typically results in no meaningful consideration of the consequences of a force majeure event occurring. So let's have a closer look at the one on the screen and ask ourselves, what would Steve Sidkin say if we put this in front of him? So as you can see, force majeure event is defined, but the definition is very much open to interpretation and does not include a list of events. If a party actually wants this clause to be triggered in the event of a cyber attack occurring, it should make reference to cyber attack in the clause itself, in the definition rather itself. Secondly, there is no requirement for the affected party to take any steps to mitigate the impact through, for example, notifying the other party of the event occurring. Thirdly, the clause does not address what happens in case of sustained non-performance. We don't actually know what would happen if a force majeure event such as a cyber attack continued and affected or led to non-performance for months on end. A more carefully drafted alternative could, for instance, include a subclause, which, by way of example, states that if a force majeure event continues for a period, say in excess of 3 months, the agreement may be terminated by either party giving notice to the other in writing. How then can force majeure clauses be incorporated into supplier agreements? Force majeure clauses may be included in agency or distribution agreements themselves, but are also commonly incorporated by reference to the supplier's terms and conditions of sale, in which case the act of incorporating such terms and conditions of sale is of paramount importance. This can be done by reference to a copy of the latest terms and conditions of sale, which is included as a schedule to the contract, or alternatively by making reference to the latest terms and conditions of sale, which could be kept outside the contract, for example, on a website. This is a more flexible approach as it obviously allows the supplier to update them from time to time, although this is normally subject to notification requirements. If a supplier fails to incorporate its terms and conditions of sale into an agency or distribution agreement, and then finds itself unable to perform its contractual duties as a result of a cyber attack, it will find itself in a very vulnerable legal position, and likely will have to resort to the doctrine of frustration, a notoriously difficult concept which is narrowly interpreted by the English courts, which thankfully for you, and perhaps more so for me, is not the subject of this talk. As an alternative, or in addition to force majeure clauses, we have also seen an uptick in suppliers, particularly those with ties to the US, include what are called material adverse change clauses in their contracts. This concept is in some ways similar to force majeure, but has as its origin US corporate law, where acquirers and lenders have sought contractual protection from unexpected events occurring between signing and completion. Short-term issues or temporary disruptions are not typically ones which are viewed as material adverse change events. However, as with force majeure events and any concept alien to English law, that doesn't really matter. English courts will look to interpret the contract according to the parties' intentions, and again, the starting point will be the terms of the written contract. If a supplier's terms and conditions of trade clearly define a cyber attack as a material adverse change event, a cyber attack will be seen as a material adverse change event. Be sure, however, in any event to check the governing law clause of any terms and conditions of sale. Common law and civil law jurisdictions generally respect exclusive governing law clauses, and while choice of law clauses cannot override certain statutory obligations, they are likely to be respected if the parties find themselves in dispute over issues relating to non-performance of contractual duties following a cyber attack. To conclude, therefore, the recent wave of cyber attacks shows that operational disruption is no longer a remote risk for suppliers and distributors. It is a foreseeable commercial reality, one that suppliers and distributors must address directly in their contractual frameworks. By preparing now, before a cyber incident strikes, suppliers place themselves in the strongest possible position to safeguard their operations, maintain their business relationships, and navigate any legal and financial fallout with confidence. Thank you for listening.
Good evening, everyone. My name is Ash, and I just wanted to say it's great to see a few faces from last year. Those of you who did attend last year will remember me with slightly more facial hair. I just wanted to assure you this is a contribution to the charity Movember, not a contribution to fashion or anything like that. Today, I'm not going to be talking about my facial hair. I'm going to be talking about agents' authorization. More specifically, when the law treats an agent, representative, or broker's words as binding on their principal. Now, in practice, agents often promise things on behalf of their principal. Only later, usually in a dispute, does the customer ask, was the agent authorized to say that? Now, recent cases show that the courts judge authority by considering appearances, conduct, and contractual wording. Now, if authority is not managed properly, a principal may still be bound by an agent that has exceeded their authority. So today, I'm going to walk through the rules of authority and then some practical examples which should show you some key takeaways for both principals and agents. So what do we mean by authority? Well, as far as the law is concerned, there's three main types. There's actual authority. An express actual authority arises where the principal gives clear, verbal, or written permission to act. For example, in an agent's contract or power of attorney. This can be contrasted with implied actual authority, which covers things usual in the course of business, like a shop assistant receiving payment and giving change. Things usual to a specific role, a task usual to a specific role, like a hotel receptionist allocating rooms for the hotel. Or customary actions, like a waiter charging service charge, no matter how shoddy the service was. Now, a principal is bound by acts done within the scope of an agent's actual authority. But if the authority is ambiguous and can be interpreted in several ways, the principal may still be bound regardless of their intention, if the agent's good faith interpretation was reasonable. We then move on to number 2, apparent authority, which is created by the principal's words or conduct, leading a third party to reasonably believe the agent has authority. It covers situations both where the principal makes someone look like an agent, even when they are not, or when they make a real agent appear to have more authority than they actually do. For example, if a principal allows an agent to negotiate every term of a contract and to sign documents on their letterhead, the principal may be presenting that agent as having apparent authority. However, there is a caveat to this, that if circumstances would lead a reasonable third party to question the agent's authority, for example, if the transaction is clearly against the principal's best interests, then the third party is put on inquiry, and they must take reasonable steps to check that the person they are dealing with genuinely has that authority. It's important to know that apparent authority does have its limits. It cannot validate a variation to a contract that goes against what the parties originally agreed, or that fails a contractual requirement for variations, for example, that they have to be put in writing. Lastly, just to touch on what we will colloquially describe as reliance-based authority, this combined a principal who says nothing, while a person who does not have authority acts on their behalf. Now, if the principal's conduct leads a third party to reasonably believe that that individual does have authority, and the third party relies on that belief, it would be unfair for the principal to deny that authority afterwards. Do note again, sort of similarly to apparent authority, this cannot be used to treat a person as authorized when this would go against what is in the contract. Again, by reason of perhaps written variation or an authorized representative. Just some very quick general points on authority before we move into some, case studies. Agents, this is a warning to you, unfortunately. If you wrongly claim to have authority, you may be personally liable. That's why you should always make clear before any documents are signed, in the case that you do not have the principal's written approval, that the deal is subject to the principal's approval. If there is a dispute, the burden of proving authority sits with the party relying upon it, and actually a principal can ratify an unauthorized act, making it binding from the outset, but such ratification must be both clear and honest. I will say there is a commercial myth of usual authority. If you do hear of this, treat it like the Loch Ness Monster. You know, it's actually just part of implied, actual, or apparent authority. So I'll now run through some recent examples or judgments that hopefully can give some practical tips for you to take away. So one recent case involved a PPE supplier working with a logistics provider and an intermediary who became the main voice between them. As pressure increased due to deadlines slipping and problems mounting, which is an understatement of the issues which came with PPE, communication became informal. And later, there was a disagreement between the parties as to whether the contract had been varied by the intermediary. Intermediaries often look like the day-to-day voice of the business, and it's natural that consumers rely on what they say. But as we know, disputes arise, and one may arise later down the line about whether the intermediary made changes to the contract. The courts take a fairly simple view, that if an intermediary looks like the business's spokesperson in everyday dealings, it does not matter, in the sense that their behavior cannot override a contract that requires variations to follow specific processes. If the contract demands signed, written changes by an authorized representative, informal emails, informal conversations, no matter how many you've had, will not do. This is also a flag of the risk of multi-layered communication chains. In a more hectic project with several go-between, there is a danger that a customer may assume that whoever they hear from speaks for the business as a whole. So the lesson from point one on the board, I guess, is to follow contractual variation clauses. Make sure only those authorized to make changes agree to do so. Otherwise, agents risk personal liability for breach of implied warranty of authority if they appear to agree variations without the necessary authority. I'll move on to a separate example, which involved an investment business who used a representative who gradually became the day-to-day voice of the business. They were the main point of contact, signing documents, sending confirmations. The counterparty to the agreement assumed that this representative spoke for the organization. There is a danger if you give someone a senior sounding title and let them use your letterhead, people might assume that representative has your authority. But the principal may actually come back and later say they shouldn't have signed that. They weren't authorised under our internal rules. As you may expect, a job title, letterhead, these sort of factors alone are not enough to give an individual authority. But if a principal is copied into emails for months and says nothing to correct the impression that a representative does have authority, that silence can support the existence of authority. So the courts focus on what the principal has allowed in practice. So what you need to do is make clear who can bind the business. If someone looks like a decision maker, the courts may treat them as authorised and as a decision maker, even if they technically lack the internal power to sign. So the third case is another recent dispute, as they all are. We're trying to keep things up to date here. And it involved a company that believed it had been drawn into a contract by misleading statements. It sent reservations of rights letters to the counterparty in order to protect itself. But it carried on performing the contract, placing orders, accepting deliveries, and making payments. Now, once again, the courts take a practical view. Actions speak louder than words. Once the business knows the relevant facts, continued performance usually amounts to accepting the contract. A reservation of rights only works if your conduct matches that. So, if you are challenging the validity of a contract, perhaps due to doubting authority, you must pause or at least limit major performance of the contract until your strategy is clear. Continuing as normal may actually affirm the contract. Lastly, another recent dispute involved a supplier whose representative made confident statements during tough negotiations about costs, pricing, and what the supplier actually intended to do in the future. Of course, they were all untrue. And once they transpired to be untrue, the buyer said, "We only agreed to this deal because we relied on what your representative told us." Where such statements are material and central to the negotiations, the courts will generally infer that the buyer did rely on them when entering the contract, unless otherwise is proven. The buyer may have several reasons for entering or signing the contract, but such a false statement only has to be one of them to create liability. Principals must remember that they are responsible for what their authorised negotiators say. Agents and sales representatives also should avoid exceeding this authority by padding out negotiations, giving assurances or predictions going beyond what they were authorised to give. Misstatements, even an optimistic forecast to smooth a negotiation, can create liability. So in brief, some consequences of unclear or overstated authority are agents facing personal liability, deals or variations not binding the principal unless formally ratified, misrepresentation or overselling can lead to a rescission of a contract or damages, silence by a principal can unintentionally create apparent authority, whilst continuing performance may unintentionally affirm a contract. Lastly, if a deal is within the agent's authority, the principal may still be bound, even if the agent has acted fraudulently, unless the third party has reason to believe, a reasonable reason to believe, that the agent was exceeding their authority. For example, if the transaction benefits only the agent. So to leave you on today, just some key takeaways for both principals and agents. Well, look, for a principal, it's simple. Define the scope of your agent's authority precisely. Communicate it clearly, both internally and externally. If the agent is allowed to negotiate on your behalf, make it clear whether they can actually agree contractual terms, and if so, put that in writing. Similarly to Guy, the term negotiate could probably fuel a 3-hour seminar in itself, and we'll spare you that for now. But if you are interested in such a 3-hour seminar tonight, I will humbly volunteer Steve to walk you through anything you would like to know, which I'm sure he'll thank me for. Back to the task at hand. In contracts requiring written variations by an authorised representative, specify who that representative is and what formalities apply. Control the use of your letterhead, branding, templates, and manage your communications, because silence can look like approval and create authority. Lastly, monitor your intermediaries. Get in contact and correct any misunderstanding of your intentions promptly. For agents, if you cannot obtain a written approval from the principal before concluding a contract, what I said before is key. Ensure that you say that it is subject to approval by the principal. Never assume authority. Get written confirmation to avoid unnecessary legal disputes and liability. Document your instructions and any commitments or representations you make to a third party, and stick to your approved messaging. Avoid guarantees and commitments outside of scope. Lastly, if you do think that a counterparty is relying on your statements, inform your principal promptly. Thank you very much.
Thank you very much, Ash. Okay, on to the topic of indemnity. And what I'm going to be doing is running you through 7 effectively subtopics. A very quick look at a judgment from Belgium. Then we're going to question the purpose of indemnity and when does indemnity arise? How is indemnity calculated? What to watch out for? I'm going to address some urban myths and then compensation or indemnity, which is better. So without further ado, one of the reasons why I thought that it would be appropriate to talk about the subject of indemnity this evening was something I read probably 4 or 5 months ago, and which caught my attention. And it was a very brief report of a decision which had been given by the Belgian Supreme Court when it was called upon to take a look at a judgment which had been given by the Antwerp Court of Appeal. And it concerned an agent of AXA Bank. The agent had the agency agreement terminated and decided to claim what we would call indemnity. The Court of Appeal in Antwerp decided that the indemnity that should be awarded was 85% of the statutory maximum, and they applied, and I'll give you the English as opposed to the Latin expression, according to what is fair and good. The agent was unhappy about this and thought that the way in which the Court of Appeal in Antwerp had gone about things was incorrect. And so the agent appealed to the Supreme Court in Brussels, and ultimately the Supreme Court in Brussels agreed with the agent. It's not a question of what is fair and good. Essentially, the Court of Appeal in Antwerp had misdirected itself. To explain, and we'll come back to this in a few minutes, the legislation both in Belgium, both in the UK, they're derived from the same source, the EU Agents Directive. And when it comes to the issue of indemnity, the directive says that the indemnity that is awarded to a terminated agent can never exceed the average of the last 5 years of commission. Or if the agency has lasted for a shorter period of time, then the average of the commission earned over the shorter period of time. And what the Court of Appeal had done is that it had simply taken a figure which it thought was appropriate, namely 85% of the maximum, and said, that's it, that's what we think should be awarded to the agent. And it took the Belgian Supreme Court to point out that actually going about it in that way was entirely incorrect. You only get to consider the maximum if, by applying a formula, and we'll come on to that in a short while, the formula results in a figure more than the maximum, because the agent can never receive more than the maximum. The agent can receive less than the maximum, but not more than the maximum. And so the Belgian Supreme Court decided that the Court of Appeal had got it wrong. Why it got it wrong, I don't know. It's a fairly straightforward process so far as the Agents Directive is concerned, and certainly English law is concerned. And I can only assume the same is true under Belgian law, but get it wrong it did, and get corrected it certainly did by the Belgian Supreme Court. So moving on from that, what is the purpose of indemnity? Well, let me take you back to when the Agents Directive was first discussed in Brussels, this time by the European Commission. And at that time, the European Commission was concerned ultimately about two things. I've put them both up on the screen, but arguably single market, and apologies for the verb, trumped the issue of fairness. The EU Commission at that time was concerned to create a single market within the European Union. Agents were regarded as a key component in extending the EU economy, and as such, it was thought that there should be some way of ensuring that wherever the agent was operating, let us say the agent is operating in France for a German principal, the situation in terms of what the agent receives when the agency agreement comes to an end should be the same if, for example, the situation was reversed and there was a French principal engaged with a German agent. So the idea was, let us create a level playing field, single market, and that will aid the economy of the whole of the EU, as was. And the concept of fairness, well, that came along because the EU Commission was alert to the fact that invariably the agent is the weaker of the parties in a principal-agent relationship. So when does indemnity arise? Well, it's probably better to ask when it doesn't arise. So let's run through these very quickly. Breach of the agency agreement by the agent, which would justify immediate termination. That's going to knock out the entitlement to indemnity for sure. Termination of the agency by the agent unless it is due to the act of the principal, effectively a constructive termination situation, or the age, retirement, or ill health of the agent, where the agent is an individual, although good luck if it's a limited company and it's the key individual, perhaps the owner of the company who wants to retire, but it is the company itself that is the agent. Good luck with discussing that one. And the transfer of the agency by the agent without the principal's consent, pretty uncommon, but it is still there in the legislation as to when it cancels out the entitlement to indemnity. So how do you calculate indemnity? So the words that you see on the screen are the words that appear in the legislation. They appear in the UK legislation, they appear in the EU Agents Directive. I'm not going to take you through each individual component, but what essentially we are looking at when we consider these words is what is the value which has been created by the agent performing the agency for the principal. Different factors are taken into account. For example, with regard to, in small Roman 2, the concept of significantly, as in significantly increased. What does that mean? Does it mean 100% increase? Well, that would certainly be significant. What about 50%? Possibly. What about 10%? Unlikely. What is significant increase? It remains to be determined, despite the fact that the legislation has been around for a very long time. The principal continues to derive substantial benefits. How do we measure substantial benefits? How long can we say that a customer which was introduced by the agent to the principal is going to continue to be a customer of the principal going forwards? It's these sorts of issues where lawyers can get heavily involved and arguably increase their popularity with the rest of society. And we also have regard to the payment being equitable, being fair in all the circumstances. Certainly, if the agent was going to continue to solicit business for another principal from the same customers that the agent had introduced to the principal for which the agent is no longer the agent, then it might be questionable as to whether that was equitable, fair that the agent should receive an indemnity. It is issues such as these which are taken into account when calculating indemnity. But to go back to the Belgian case, the tailpiece makes clear that it is capped. It cannot exceed more than the average of the last 5 years. What to watch out for? Looking at this from the perspective of the agent, but also to a degree from the perspective of the principal. Keeping records, absolutely key. Certainly in our experience, records are kept more casually than perhaps they should be kept by both principal and agent. And when it comes to having a discussion, otherwise known as a fight, about the entitlement of the agent in terms of how much to an indemnity, records can win the day for either party. Continue to act in respect of such customers. I've already touched on that in terms of the issue of fairness. The question of timing. If the agency agreement is ended, the agent has a period of 1 year in which to notify the principal that the agent intends to claim indemnity, or for that matter, the alternative, compensation. Failure to do so will disqualify the agent from proceeding with that particular claim. It is a case of notify or lose it. No two questions about that. Some urban myths. Invariably, we are told when we're instructed, the agent's entitled to the maximum. It's the average of the last 5 years. Or we're told it's the average of the last 3 years, or more recently, the average of the last 2 years. To which the short answer to all three is no, it isn't. Because it isn't always the maximum. What we're talking about is the concept of entitlement. Nothing more, nothing less. There's a difference between being entitled to something and actually having that something. And as that is true of life, as it is true of the law. Simply because the law says you have an entitlement doesn't mean that you can simply pick it up and go away somewhere. You have to enforce your entitlement. And that goes on then to the second bullet point. An entitlement equals an ATM. So the equivalent of after this evening's seminar, you decide that actually you need some cash in your pocket rather than rely on your phone or your card or whatever it is, or your watch. And so you happen to be passing a bank, there's an ATM, you decide you're going to put in your card and take out some cash. And that the entitlement to indemnity is exactly the same. It is not, and I cannot emphasize that more strongly. So, compensation or indemnity, which is better? Well, the typical answer from a lawyer when asked that question is, well, in fact, any question that might be asked to a lawyer, is it depends. Certainly, there are various factors to be taken into account. Compensation is a forward-looking. What is the agency going to be worth in the foreseeable future? And that will determine the amount, or certainly point to determining the amount that the principal may be liable for following a termination of an agency. In contrast, indemnity is backward-looking. What has the agent achieved for the principal? What is the agent going to lose as a result of the agency being terminated? What is the other side of the coin, the principal going to gain as a result of the termination? Valuing the individual component, and here I'm addressing very much the compensation entitlement of a terminated agent. And bear in mind, compensation or indemnity, these are alternatives. You can choose, but if you don't, it's compensation by default. So when it comes to the individual component, what we're concerned about there is the individual. If the agent is an individual, then that particular person, or if it's an agent is a company, then the owner of the company or the managing director of the company. What would the agent bear in terms of cost by the agent not being the person doing the work, but engaging someone to do the work for the individual, whilst that individual perhaps goes off and lies on a beach somewhere? And that is important because invariably that is a key cost which has to be taken into account when valuing the compensation entitlement of a terminated agent. And often it is overlooked when it comes to valuing compensation. And again, on the compensation side, upwards, plateauing, or downwards. Essentially, if compensation is forward-looking in terms of what is this going to be worth going forwards, then there needs to be taken into account how the particular business for which the agent has been acting as an agent is going to be likely to be performing going forwards. Essentially, given the way in which compensation is calculated, the notional purchaser of a terminated agency is going to be prepared to pay more if that individual thinks that the business going forwards is likely to increase or perhaps has plateaued at a suitable high point. And in contrast, where the business is on the downward slope, then the chances are that it's going to command a lower price and result in a lower amount of compensation. So in terms of compensation or indemnity, which is better, as I said at the outset, it depends. But do bear in mind, it is the case of the parties choosing. If they don't choose, it is compensation. And it's a question of looking at the situation and taking a view, because nothing more can be done if you're the agent, as to whether compensation or indemnity at some point in the future is likely to be better for you. And I can't give you any more guidance than that, unfortunately. Right, that is the end of that part of the seminar. Q&A. The speakers to my right will be very happy to answer your questions. And if you want to, I shall also try and answer them. But over to you. If there are any questions, we shall try and give you some answers.
Even when is it worth pursuing legally in terms of the value of compensation? For example, if you've got a claim of a small claim, £10,000, that you believe is valid, is it worth going legal?
If going legal means instructing a law firm, probably not.
But at what level would it become viable?
It can't be said at what level it becomes viable, because it can't be said at what time the other party, the payer, the principal, is going to say, okay, we will make a bank transfer or we will write a check. None of us in this room can predict when that is going to happen. There is a matter on at the moment that we're dealing with. It involves an extremely well-known brand in its particular trade sector. Clearly, I'm not going to name it, but extremely well-known, household name. Do we expect that it is going to fight? Well, we've been put on notice, given what we've heard on the grapevine, that yes, it will fight, and it will be prepared to spend a very significant amount of money to defend its position. Does that make sense for it commercially? Probably not. So does that mean that the agent's going to have to fight even harder than might otherwise been the case? Probably yes. But who knows? Tomorrow we may wake up and find that the brand has decided to make payment. We can't tell. And as such, we can't tell when does it make financial sense to pursue a claim. If Europe means the European Union, then in very broad terms, the aspects that I've mentioned, the aspects you've seen on the screen, will be the same within the rest of the European Union. There are some differences by reference to the way in which the law is interpreted, but the whole starting point of the EU Commission deciding to try and create one law to help establish a single market means that there is a great degree of harmonization between, for example, German law and Spanish law, much more than probably is the case in any other area of the law so far as the two countries are concerned. So across the European Union, a fair degree of harmonization, a fair degree of commonality, but yes, there will be individual courts in different countries that have decided things in a particular fashion for that country.
Speaking there, Chris Boss. Give me a...
Yes, the rules apply in pretty much the same way, although question the position where the individual who owns the company says, I want to retire. And as a result of wanting to retire, that's it, going to close the agency and make a claim under the regulations. Where the individual is an individual agent, then yes, that should be the way forward, although we can have a discussion as to at what age or what degree of ill health the agent needs to be in before making the claim. But where the agent is a limited company, limited liability partnership, then there can start to be issues that need to be considered.
Steve, can you expand on the age thing about retirement? Is it statutory? Is it? How does that apply for an individual?
There's no good answer. Unfortunately, if we take, okay, so once upon a time I would give an example by reference to the skateboard industry, where most skateboarders, so far as I'm aware, are probably less than 20 years of age. So there, if an agent as an individual reaches, let's say, 35, are they really connecting with teenagers half their age, which are the core market? Probably not. If we're talking these days, let's say about padel, which I think in terms of a popular sport has overtaken skateboarding. Most padel players, I would guess 20s, 30s. You get an agent, 60s. So it depends. And it is not necessarily linked to state retirement age, if that's where your question was headed. There was a consultation. Various parties made submissions to the government. Certainly we did. And ultimately, it was the last Conservative government. There was a decision made that the regulations would be retained. At the moment, yes, although with the current government, I've got my own views as to what will be the position, not simply tomorrow, but next week, on any particular issue you care to name.
I've got a question from earlier, sort of by David.
Thank you.
I'll give you a break. What's the answer? You mentioned tow rates, and we had a tow rate at one of my companies that I worked at about 12 years ago. There was not patience and source of the rest. He had a budget around that. So happened by chance, he was on a holiday for 2 weeks, and the CEO took his office phone away and was asked if that Rob listed for let the factory speak to him. He goes, they would like the money wiring. And needless to say, at last, but it is no stage of kickback. My definition is that all the same thing?
Yeah, possibly. I mean, just because you do potentially different language, different forms, but essentially the same thing. It's really interesting. a lot of companies to say actually really it's good.
Yeah, this is like a 1-2% scheme. The benefit was commission.
Yeah. Did you get the money? It's always a shame, isn't it? Because if you take action, so advice, I think that's why people. I think it's the factories they wanted to.
And on that, I think that the case that Evie referred to, which was Charles Clare and Lynx Golf against Kevin Walker, I suspect there, though it was not stated in the judgment, there was an issue of keeping the factory sweet for some time, or keeping the supply base sweet for some time. That this didn't get uncovered, because certainly when I read the judgment, it seemed to me to be pretty obvious from the outset as to what had been happening.
Just while I'm adding stuff, on the is it viable to sue someone to check any shots? Because actually that way change the dial. Apple may suddenly tons of your choice. It's often. People expect this stuff off, it doesn't cost too much money. Changing the balance. And sometimes we're often on the other side. We expect it's insurance. Is this you work Canada? Should we sell? Just so around.
Okay. Thank you all very much indeed for your questions. Thank you very much for listening to our speakers this evening. And if you'd like to show your appreciation in the normal way, and then let's adjourn for some drinks and for some canapes. Thank you.